So the Supreme Court just issued a 6-3 decision which found that you cannot sue an individual law enforcement officer even if that law enforcement officer knowingly fails to read you your Miranda rights. So let's talk about this. But real quick before we jump into this video, if you memorized your Miranda rights by watching Cops, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Nautilus Ammunition. Nautilus Ammunition provides cheap, high quality ammunition that is made in America. You can get 223 or 9mm for $3 to $5 cheaper per box than you would at other retailers. Nautilus provides fast shipping, and if you ever have any issues, you can call them and speak with someone who's actually a real person in America. To get updates from Nautilus Ammunition, head on over to their Instagram page, which I will link down below. And I want to thank Nautilus Ammunition once again for sponsoring this video. So like I said in the intro, the Supreme Court just issued a 6-3 decision in a case involving Miranda warnings and your potential ability to sue law enforcement officers who actively fail to read you your Miranda rights. Law enforcement failing to read you your rights is always of great concern, especially when you have rogue federal agencies like the ATF who target specific individuals for exercising their Second Amendment rights. With this decision by the Supreme Court, law enforcement officers and agencies no longer have to be concerned with the prospect of being sued individually for violating your rights. The Supreme Court's decision found that a law enforcement officer cannot be sued for damages even if the law enforcement officer knowingly fails to read you your Miranda rights and then coerces a statement from you. The case we'll be talking about in this video is Vega v. Tecco. This was a 6-3 opinion authored by Justice Alito, and the question before the Supreme Court in this case was whether a plaintiff may sue a police officer under Section 1983 based on the allegedly improper admission of an un-Mirandized statement in a criminal prosecution. So what does this case involve and how did it end up before the Supreme Court? Well, in March of 2014, Tecco was working as a certified nursing assistant at a Los Angeles medical center. Then a female patient accused him of sexually assaulting her. The hospital staff reported the accusation to the Los Angeles County Sheriff's Department, and Deputy Vega responded. Officer Vega questioned Tecco at length at the hospital, and Tecco eventually provided a written statement apologizing for inappropriately touching the patient. The parties dispute whether Vega used coercive techniques to actually extract those statements. Some reports included that Vega had his hand on his firearms during the questioning and also that he threatened Tecco. But what is undisputed in the facts is that he never read or informed Tecco of his Miranda rights. Tecco was arrested and then charged in California State Court. At Tecco's first trial, the judge held that Miranda had not been violated because Tecco was not in custody when he provided the statements, but the trial then resulted in a mistrial. When Tecco was retried, a second judge again denied the request to exclude the confessions. That second trial resulted eventually in an acquittal, and after that acquittal, Tecco then brought this case and cause of action under Section 1983 against Deputy Vega and other defendants. This case eventually made its way up to the Ninth Circuit, and on review, the Ninth Circuit agreed with Tecco, holding that the use of un-Mirandized statements against a defendant in a criminal proceeding violates the Fifth Amendment and may support a 1983 claim against an officer who obtained those statements. That decision by the Ninth Circuit was then appealed up to the Supreme Court, and that is what's being reviewed here in this case. So that's the background surrounding this case. Now, if you're not aware of what Miranda refers to or what Miranda warnings refers to, let me explain real quick. A Miranda warning refers to the constitutional requirement that once an individual is detained by police, there are certain warnings a police officer is required to give that person. Think about when you're watching Cops and you hear an officer say the classic statement, "You have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be provided to you. Do you understand the rights that have been read to you and as they have been read to you?" In the Supreme Court case Miranda v. Arizona, the Supreme Court held that a defendant cannot be questioned by police in the context of a custodial interrogation until the defendant is made aware of his or her rights. Miranda warnings are important when it comes to criminal proceedings, and that is why it is required that law enforcement read them to you if you are in custody. Without a Miranda warning or a valid waiver of your Miranda rights, statements made by you are inadmissible at trial under the exclusionary rule. The exclusionary rule prevents the government from using evidence at trial which was gathered in violation of your constitutional rights. Also want to make a distinction between two types of court cases. There are criminal cases and civil cases. Miranda rights directly impact criminal cases. In criminal cases, if you are arrested or detained and you were not read your Miranda rights, any statements made during that period are excluded from being used against you. That is the traditional remedy that is available in these criminal proceedings. This case, Vega, implicated something else. The individual here wanted to sue a police officer and hold that police officer civilly liable through a civil lawsuit for failing to read Miranda rights to him. In this 6-3 opinion by the Supreme Court, the court said the failure to Mirandize you does not lead to an additional civil remedy. Essentially, the ruling of the Supreme Court says that they are not going to create a civil cause of action from something that has been purely criminal in the past. In reaching their decision, the court stated, a violation of Miranda does not necessarily constitute a violation of the Constitution, and therefore, such a violation does not constitute the deprivation of a right secured by the Constitution for purposes of Section 1983. A Section 1983 claim may also be based on the deprivation of any rights secured by the laws, but the argument that Miranda rules constitute federal law that can provide the ground for a Section 1983 claim cannot succeed unless TECO can persuade the court that this law should be expanded to include the right to sue for damages under Section 1983. A judicially crafted prophylactic rule should apply only where its benefits outweigh its costs. Here, while the benefits of permitting the assertion of Miranda claims under Section 1983 would be slight, the costs would be substantial. For example, allowing a claim like TECO's would disserve judicial economy by requiring a federal judge or jury to adjudicate a factual question, whether TECO was in custody when questioned, that had already been decided by a state court. Allowing Section 1983 suits based on Miranda claims would also present many procedural issues. Miranda and its progeny provide sufficient protection for the Fifth Amendment right against compelled self-incrimination. For those reasons, the court found that there is no ability to sue a law enforcement officer and hold them civilly liable for failing to read you your Miranda rights. So the Supreme Court made some important distinctions in reaching their decision. First, they reiterated that Miranda created a rule that law enforcement officers must follow in order to not violate your rights. However, the Miranda reading itself is not a right. Also, they found that the criminal remedy of excluding evidence was sufficient enough of a protection that they didn't then need to expand into civil protections as well. The court believed adding a new remedy would open a can of worms that outweighs the benefit of actually allowing these types of civil suits. So really the question is, what impact will this have going forward? Will law enforcement officers be more emboldened to not read Miranda rights since they know that they have protection against being sued individually, or will this just be business as usual? There is already the risk that failing to read Miranda warnings will lead to the exclusion of evidence that police officers gather during those questionings. That alone may be enough of a deterrent, but as we saw in this case and others, there are police officers that are more than willing to walk the gray line, right? Walk that gray area and not give you your Miranda warnings in order to get statements out of you and then try to use those statements during a trial. And with the increase of federal agency actions like those by the ATF, this is something that gun owners need to be aware of. These law enforcement officers, these agencies now know that they are protected civilly by the Supreme Court decision, and the only thing that now is at risk is maybe losing that statement at a trial, but they may be willing to walk that line just to get a statement out of you. But if you take nothing else from this video, the main takeaway from this is, when in doubt, say you want an attorney and then shut your mouth. So that is what you should do. That is something you should always keep in mind. Don't talk to law enforcement until you actually have an attorney, and if you don't have an attorney, exercise your right to be silent and don't say anything. So if you have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.